In Irish workplace safety law, a critical concept for employers is reasonably practicable. Understanding this term is fundamental for ensuring compliance and fostering a safe working environment across various industries. This video will explain what reasonably practicable means under Irish law, delving into its historical context and modern interpretation. Prior to the 2005 Act, courts interpreted reasonably practicable by balancing the risk of a hazard against the cost of removing it. If the risk was low, but the cost of fixing it was very high, the employer might not have been required to take further action. This approach allowed for a pragmatic assessment, where disproportionate expenditure for minimal risk reduction was not always mandated. A key example illustrating this principle is the case of Boyle versus Marathon Petroleum, a landmark decision in Irish safety law. Mr. Boyle worked on an offshore gas platform where workers frequently complained about the danger of using ladders to access valves and gauges. These ladders presented a significant and frequent risk of falls and other injuries due to the nature of the work. In response, Marathon Petroleum installed an intermediate floor to remove the need for frequent ladder use, thereby mitigating the primary hazard. However, this modification inadvertently reduced headroom in some specific areas of the platform. Tragically, Mr. Boyle was injured when he hit his head on a girder because of this reduced headroom in one of these modified sections. The courts, including the Supreme Court, ultimately found that Marathon Petroleum had acted in a reasonably practicable manner despite the unfortunate incident. They reasoned that the significant risk of frequent, dangerous ladder use was removed and replaced with a much lower residual risk of infrequent work in a low headroom area. The Supreme Court emphasized that this statutory duty is higher than the common law duty of care, placing a greater onus on employers. The employer must prove they took all practical steps to ensure safety, demonstrating a proactive approach to risk management. The Safety, Health and Welfare at Work Act 2005 provides a more explicit definition of reasonably practicable in Section 2. This modern definition clarifies the employer's obligations and has 4 key components that must be considered. First, the employer must exercise all due care, meaning they must act diligently and responsibly in their safety efforts. Second, they must put in place necessary protective and preventative measures to safeguard their employees. Third, they're obligated to identify hazards and thoroughly assess the risks associated with those hazards in the workplace. Finally, further measures are not required if their cost is grossly disproportionate to the risk, providing a crucial caveat. This means that while the standard is high, there is a limit to the extent of measures required when the cost far outweighs the benefit. Reasonably practicable has evolved to mean a high standard requiring proactive risk management by Irish employers, moving beyond simple common law negligence. It demands continuous vigilance and a commitment to safety that is deeply embedded in operational practices.